Hello, and welcome to All Things Chemical, a podcast produced by Bergeson and Campbell, a Washington, D.C. law firm focusing on chemical law, business, and litigation matters. I'm Lynn Bergeson. The podcast you're about to hear is the panel discussion on risk management. This panel focuses on the past, present, and future of risk management under TSCA. With all 5 risk management rules in litigation, a debate is currently underway whether these rules go too far or not far enough on how much risk reduction we can expect in future rules. The panel also explores what can be learned to date about the pending cases and speculate on how the courts and EPA may reshape futures TSCA Section 6 rulemakings. The panel will also address recurring policy and legal issues, such as the role of TSCA Section 6 in assuring workplace protection and addressing environmental releases from facilities, as well as how EPA can keep pace with TSCA statutory deadlines for proposed and final rules. Now, here's the panel discussion on risk management.
Moderating this panel, we have Martha Marapeace, who is a partner at Wiley Ryan. She's a recognized leader on TSCA matters. Martha provides strategic counseling to clients on how to navigate TSCA's NCP effectively, negotiates consent orders on their behalf, and advises on how to best practice confidential business information in TSCA submissions. She assists clients as they navigate EPA's existing chemical prioritization, risk evaluation, and risk management processes, and advocates for reasonable workplace requirements associated with their condition of use. She's also on our TSCA Reform Conference Steering Committee. Martha, I will turn things over to you to get us started. Thank you so much.
All right. Thank you. And welcome, everybody. And apologies in advance to the folks over on this side. I have my back turned to you a little bit. But we want to, I've been just excited to be part of the steering committee for this event. 10 years is a big deal. And we're going to talk about risk management in this panel discussion. With me to have the discussion, we have Keith Bradley, who's a partner with Squire Patton Boggs, and Marissa Smith, PhD, senior regulatory toxicologist with the Washington State Department of Ecology, on the screen with us today. Here next to me in the room is Bob Sussman, who's principal with Sussman and Associates. Next to Bob, Reagan Gieschenschlag, who's director of Chemicals, Materials, and Sustainability Policy with the National Association of Manufacturers. Next to Reagan, the Honorable Michal Friedhoff, PhD, Senior Policy Advisor with Holland and Knight. And next to Michal is Randy Rabinowitz, who's Executive Director of the OSH Law Project. We've asked Michal to kick off our topic today. So Michal, I want to turn it over to you.
Thanks. Well, hi, everybody. And thank you so much for the invitation to this annual gathering. This is the time of year when my social media kind of explodes with reminders on a near daily basis of pictures memorializing TSCA votes, the White House signing ceremony, the many TSCA parties we had after the bill was, finally finished, the first major rewrite of an environmental law in a generation. It's really hard to believe it's been 10 years. And of course, none of us look even the tiniest bit older. So I always think when talking about where we are and where we're going, it's good to start with a bit of the past. The original 1976 TSCA, like so many of our bedrock environmental statutes, was born of decades of our collective failure to manage the way chemicals were used, made, and disposed of. After trees in the Love Canal neighborhoods turned black and people started noticing that their kids' hands were burned when they came inside. After the Cuyahoga River caught on fire more than a dozen times. After cancer clusters in communities surrounding old factories started to be found. After about 20 million people participated in the first Earth Day in 1970, and after Richard Nixon created the EPA later that same year. And I think it's important to remember that as Congress was writing some of our other bedrock environmental laws, like the Clean Air Act, the Safe Drinking Water Act, it was the Nixon administration that asked Congress to write what ultimately became the Toxic Substances Control Act, saying, quote, "We should no longer be limited to repairing the damage after it has been done, nor should we continue to allow the entire population or the entire environment to be used as a laboratory." There's been a lot of debate about what 1976 TSCA did or did not include, and what 2016 TSCA did or did not change. For example, I've heard people insist that workers were never part of the original TSCA. But that's simply not the case. The truth is they were there from the start. When the head of the Nixon administration CEQ testified before Congress on the need for the law, he used a few different examples related specifically to workers. For example, he talked about how vinyl chloride had been on the market for decades before it was classified as a carcinogen, after a number of workers had already died of the rare liver cancer that it caused. The original 1976 law even had language in it that ensured that if EPA regulated a workplace use of a chemical, that wouldn't trigger the preemption of the rest of OSHA's rules related to the safety of those same workplaces. And as much as we all know about the famous court decision striking down the asbestos ban that tied EPA's hands on existing chemicals until the law was rewritten, you can go onto EPA's website and see some of the rules they wrote that weren't struck down. There are several TSCA rules from the 1980s that are only about workers. And of course, although OSHA has written some chemical-specific safety rules, many of them date from the 1970s, and their webpage, at least at one point, said that those rules were outdated and inadequate. That's a quote, to protect workers' safety. So for those who think the 2016 law is the only reason why worker safety has been front and center for EPA's TSCA risk management work, that's just not the case. Worker safety has always been a central focus. But it's useful to talk about what did change in 2016. Congress just didn't want EPA to regulate single uses of chemicals anymore. It wanted a comprehensive scientific look at the way each chemical was made and used, and then a comprehensive safety solution. In fact, we had to write specific provisions to allow EPA to move forward with several single-use rules that it was almost ready to propose. Provisions EPA actually came to Congress and asked us to write just to be sure that our new comprehensive risk evaluation and risk management system wouldn't prevent them from quickly addressing some pretty significant risks for chemicals like methylene chloride and TCE. So for those who believe that EPA has the discretion to categorically exclude uses from its review, whether that's risks from drinking water or air emissions, risks to workers, risks to consumers, or risks for risks to communities, I'd say the legislative history really doesn't support that view either. I simply don't think that a systemic failure to protect consumers, communities, and other potentially exposed subpopulations is legally defensible or consistent with the chemical safety goals that Congress had. That said, with all 5 Biden-era chemical safety rules still under litigation, and with 0 proposed, revised, or finalized rules in the Trump administration, there's also a lot that's unsettled, and more I think that EPA could do to shore up its rulemaking efforts. So first, there's been a lot of debate about the way the use of PPE is considered. It turns out the first Trump administration OSHA told the first Trump administration EPA not to consider the use of PPE when making risk determinations, and the Biden administration adopted that policy. I still think it makes sense, especially because when you look at OSHA's top 10 list of most violated safety rules, PPE is always on it. So information reasonably available to EPA generally doesn't support assuming that PPE is always provided and appropriately used. And in fact, no OSHA rules allow routine reliance on PPE use. It can only be used when other ways to reduce the risk are exhausted. I do strongly agree that in risk evaluations, EPA should analyze whether PPE mitigates the unreasonable risks it finds and tells everyone what they found. And to that end, I thought the risk communication in several draft or final risk evaluations released earlier in this administration did a good job at saying, yes, we found unreasonable risk, but you can see it goes away or gets smaller when PPE is used. Second, there's still considerable debate about whether a risk determination should be made for the whole chemical or separately for each use. I can tell you that we believed there would be a single risk determination for the whole chemical substance when we were negotiating the law. But I also acknowledge that we didn't game it out precisely. I think that a requirement to make separate use-by-use determinations could make it difficult for EPA to make a determination that aggregate exposure from multiple uses of a chemical pose an unreasonable risk if each individual risk does not. I also think it could complicate EPA's ability to effectively regulate consumer uses if it also found that distribution and commerce to consumers or retail establishment for sale to consumers did not pose an unreasonable risk. So there's an area that I think there is the most opportunity for EPA, industry, and labor to work collaboratively is to further flesh out what an effective and implementable worker safety program might look like. When I was at EPA, we entered into an MOU with OSHA in the hopes of doing that, but I think more work would benefit everyone. More could be done by industry to make sure EPA has a complete understanding of the way chemicals are made and used, including the way workers are protected. More could be done by EPA to sync up the timing associated with required and follow-up air monitoring with any similar requirements that OSHA has. More could be done by EPA to consider how a facility that makes or uses more than one TSCA-regulated chemical at the same time could comply with more than one TSCA rule at the same time. And more could also be done by industry to ensure EPA has usable air monitoring data for specific uses in order to support any assertion that whatever EPA is proposing can't be done. Finally, I think it's important to remember why the risk evaluation and risk management system was needed in the first place. It was because in 1976, Congress grandfathered in tens of thousands of existing chemicals without requiring any further review under TSCA. So for decades, as other environmental laws were used to clean up the air, water, and land, TSCA did nothing to prevent more contamination from occurring in the first place. In 2016, Congress was clear that it wanted the TSCA existing chemicals program to be a conveyor belt that imposes the necessary protections for a chemical and then moves on to review and regulate another existing chemical until EPA was done. But with only 5 existing chemical rules on the books, and no apparent progress on proposing or finalizing new rules in the past year and a half or so, I'd say the conveyor belt isn't working terribly well right now, or terribly quickly. I hope that changes. I'd also say that whether you're a company that wants federal chemical safety rules in order to avoid different state laws, or you're a worker who rightly doesn't trust an OSHA rule written more than 50 years ago, or you live somewhere that's surrounded by industrial facilities, or you worry about the chemicals that might be in the toys your kids play with. We were all invested in building a credible federal chemical safety program 10 years ago, and I hope that we remain just as invested in that same goal for the next 10 years and beyond.
Thank you, Dr. Friedhoff. We're now going to start with our panel discussion. And as you all should know, Dr. Friedhoff led the TSCA program for several years in the Biden administration as Assistant Administrator of OCSPP. And given the case that Dr. Friedhoff has made in her opening remarks, a compelling case for EPA's workplace authority, I'd like to ask our panelists if you agree with EPA's approach today to protecting workers in Section 6 risk management rules. Or has EPA taken an overly expansive role in regulating the workplace, and should it pull back? Randy, would you like to lead off?
Yes, I'd be glad to. Thank you for having me. And I just want to preface my remarks by saying they're my own thoughts as someone who's practiced occupational safety and health law for more decades than I care to admit, and not those of my clients. So I think that EPA has done a generally good job in mirroring OSHA's approach to comprehensive health standards. And by that I mean for the 35 to 40 chemicals for which OSHA has adopted comprehensive health standards, each has followed a pretty similar pattern of setting an exposure limit, setting an action level, requiring certain monitoring protocols, initial monitoring, periodic ongoing monitoring, depending on how high a level the initial monitoring identifies, reliance on the hierarchy of controls, limited use of respirators, except for a handful of operations where engineering controls and work practice controls may be infeasible. And I think EPA has done a really good job of incorporating that model. The EPA risk management rules differ from the OSHA rules in a couple of respects, which I don't think are inconsistent. So the first respect that they differ in is the ECLs are substantially lower than OSHA's PELs. And there's a good reason for that. The first is OSHA has never been able to reduce a risk below the level of 1 in 1,000, and EPA has set its target for unreasonable risk at 1 in 10,000. So of course the levels that EPA sets are going to be an order of magnitude lower than the lowest levels OSHA's been able to adopt. But for the most part, OSHA's exposure limits were based on science from the 1950s and the 1960s and consensus standards that were in existence in 1970 when Congress grandfathered them in, and they have not been revised since. EPA is working on 50 more years of science. And so we would expect that there would be differences in what the outcomes would be. So I don't think having a lower exposure limit it makes it any different. It's not an exposure limit that OSHA will be able to enforce, at least under the current regime, but it does require compliance by industry. And I think the two other major differences are OSHA comprehensive health standards all include medical surveillance requirements. EPA's do not. And EPA lacks, I think there's a consensus that EPA lacks the authority to require medical monitoring in workplaces. And then the second, the more notable difference is when OSHA sets a standard, it does an industry by industry evaluation of what controls can be expected to be incorporated. And the courts have said that when OSHA does that analysis, it gets a presumption that its exposure limit is feasible and can be met without respirators. EPA is not doing that level of use-by-use analysis of the way in which different industries are likely to comply. So EPA has left it up to employers to do the analysis themselves, which I think gives employers more flexibility to reach an outcome that differs from the ECHO. But it does shift the burden onto employers to do the analysis and figure out what the the limits of engineering and work practice controls are before they implement respirators. I would say that one other significant difference, and I don't know that this has real impact for risk management, but OSHA rarely quantifies non-cancer risks. OSHA quantifies one risk, usually cancer, and if it hits the 1 in 1,000 mark, it doesn't quantify anything else. EPA has set about quantifying most of the hazards that they find, and in a number of risk evaluations, it's the non-cancer risks that are driving the risk management and not necessarily the cancer risks. And so the couple of other differences, significant differences, are EPA is covering all owners and operators. So OSHA is an employment law. It's not a chemicals law. So there have been a lot of debates under OSHA about how you deal with leased employees or independent contractors or other people who may be on site but don't report to the owner of the work site, that's not an issue under EPA because they're regulating owners and operators, and their rules are not tied to the employment relationship. So I guess that's my assessment of how that EPA has done a pretty good job of following OSHA. And I would say that the two agencies are talking a lot more than the last panel suggested. It's just that they're talking privately, and EPA is not publicly disclosing the nature of those discussions. So.
Thank you. Those are great perspectives. Do other panelists have additional comments on the EPA-OSHA relationship?
Yeah, definitely. On behalf of manufacturers, I think that conversation between EPA and OSHA, it would be beneficial if that was more transparent and provided in the record so that the manufacturers or the industry can have more insights onto OSHA's input into those risk management rules when those options are being considered. I think generally my view is that there is room for improvement, and I think Dr. Friedhoff hit on some of those areas in her remarks for EPA's approach in to risk management rules. Some of that would be that it would be more transparency and more consistency, maybe a framework or reliable rules of the road so stakeholders know what to expect and what information should be provided to the agency and how those risk management, EPA is picking those tools to address that unreasonable risk when it's identified. What I've heard from some of my members are inconsistencies in some of the risk management rules that we've seen so far, creating confusion and increased complexity that makes it difficult to implement at the facility level. Some of those are differences in monitoring cadences, which you mentioned, acceptable PPE, compliance timelines, and maybe treatment of impurities or byproducts. And that makes it challenging, and you highlighted this as well, when a facility is trying to comply with multiple of the risk management rules that we've seen. So it doesn't necessarily mesh with the holistic workplace safety approach that these EHS professionals or industrial hygienists are accustomed to implementing at the facilities that they're, considering and trying to protect their workers and then comply with the necessary regulations, having a single plan for a specific chemical when multiple chemicals are used in the workplace.
Did you want to say something about that?
Yeah, just quickly, I wanted to reinforce Randy's point that there is considerable alignment between the framework that OSHA historically has used to regulate the workplace and the framework that we see in the 5 risk management rules that Michal described, and so I would caution all of us against leaping to the conclusion that EPA is somehow creating a whole new scheme for workplace protection, which has no resemblance to what OSHA has been doing for a very long time. I think the level of alignment is pretty high. Now, there are differences, and those differences, I think, reflect differences between the two statutes, as Randy was saying. And the biggest difference in my mind is that the OSHA Act is based on the concept of regulating to the limit of feasibility, and the TSCA risk management framework in Section 6 is an unreasonable risk framework. EPA must identify whether the substance poses an unreasonable risk. It cannot take into account cost and non-risk factors, and then it must do what is required to eliminate the unreasonable risk. That's a very different approach from the feasibility approach that we are seeing on the OSHA side. But I just want to emphasize that some people are making the assumption that we have a real serious and fundamental problem because EPA is regulating the workplace after years of OSHA regulation. And I don't think we really have a problem. And in fact, in some ways, from the standpoint of worker protection, we have the best of all possible worlds here. And I think the 5 risk management rules are pretty compelling evidence that EPA is using TSCA to materially improve protection of workers.
So Martha, can I just add one quick comment? I would agree with Reagan that EPA should disclose some of its the comments it gets from OSHA and NIOSH on both risk evaluation and risk management. I would also add that my clients have tried to introduce those in court, and at least many of those comments during the first Trump administration disagreed strongly with the approach EPA was taking to risk evaluation.
One piece that I would also like to add on the general alignment with OSHA's approach, I think when it's not fully consistent, that does create, or at least from what I've heard, creates a lot of confusion with those safety professionals trying to implement OSHA's requirements and TSCA risk management rule requirements. So when wording is just slightly different, right, and you're looking at your risk management plan, those are kind of interpretations that those safety professionals are having to take on and slice how to put their safety plans together at the facility. So I think more consistency, especially around like definitions of terms in those areas, could be really beneficial.
Can I add just a couple of thoughts? One is that although the concept of an ECHL, the concept of an exposure limit, and then you have to engage in controls to keep below it. That is obviously similar to how a lot of OSHA standards work. The devil is in the structure and the details. So one thing is the holistic approach that EPA is attempting is massive. To say I'm going to write down any given chemical. And I should, by the way, I should preface, as Randy did, these are my own thoughts, not those of my clients, not those of my law firm. But to say I'm going to take this chemical and I'm going to write one rule that just covers how it gets used across everything. I took Randy's point that it's on the employer now, different from the OSHA regime. It's on the employer to say how we use it. But in an environment where there's a lot of skepticism on all sides, I don't think EPA trusts industry. Industry doesn't trust EPA, and there's in the Third Circuit right now, there's a case which is largely about whether EPA was whether it was proper to lump in a particular form of recycling and whether they had adequate reason for that. It's like a failure on the the industry's allegation is a failure to recognize that X is sufficiently different from Y and should be treated differently. In the OSHA framework, that kind of discrimination between different usage situations and different workplace models is very normal and natural, and the holistic approach tends to sweep that under the rug, even without intending, because it is such a massive undertaking. The other thing is that even if you wrote the same rule, and obviously, although as Bob said, it mirrors OSHA. We've also heard that it mirrors OSHA, but then they write the EPA will tend to write the standards much tighter. The enforcement mechanisms are so different under TSCA from what they are under the OSH Act that it is a different regulatory regime, even if the content of the regulation were the same.
Thank you, Keith, and thank you to all the panelists for addressing this topic. It's really front and center for risk management under TSCA. So we wanted to make sure we aired many of the issues for you today. I'd like to turn, if we can, we have a tremendous opportunity today with the panel because we have 3 attorneys with us who are involved in the litigation of the risk management rules that have been finalized by EPA. Oral arguments in the asbestos case, Texas Chemistry Council v. EPA, just took place earlier this week, June 1. And so I'd like to ask the panel, as this and other appeals of EPA's risk management rules proceed, how are these cases sorting out EPA's discretion to select from among the various risk management options in Section 6A of TSCA? Specifically, do you think the "to the extent necessary" instruction in Section 6A to address unreasonable risk places any constraints on EPA's authority to ban chemicals rather than to impose less sweeping restrictions? Bob, would you like to lead us off?
Yeah, sure. Well, I participated in the oral argument in New Orleans on June 1st on the EPA Part 1 asbestos rule, and there are multiple challenges to that rule. We have a labor challenge that Randy is spearheading. We have a challenge by the Asbestos Disease Awareness Association, which is my client, and then we have industry challenges, which are being spearheaded by the American Chemistry Council. So the fact that this case is being heard by the Fifth Circuit has enormous symbolic importance, because in 1991, it was the Fifth Circuit that overturned EPA's comprehensive 1989 ban on asbestos. And it was the frustration with that decision and the disappointment that in many respects was a big driver for reworking and strengthening the risk evaluation and risk management framework in Section 6 of the law. So here we were back in the court that had overturned the original asbestos ban, and that court was now 40 years later examining an EPA redo of the original OSHA rule. And let me talk about some of the arguments. I want to focus on the industry arguments. There were really two issues that are that industry is putting in play in that case. The first issue, interestingly, is whether EPA should have referred asbestos to OSHA and stayed its hand. And the second issue, remarkably, is whether EPA went too far in banning chrysotile asbestos, whether EPA should have refrained from banning chrysotile asbestos and instead relied on workplace controls to address the unreasonable risk. Now, from my perspective and the perspective of my client, it's somewhat surrealistic that here we are in 2026 and we're arguing about whether asbestos should be banned in the United States of America when asbestos has been banned by virtually all the developed economies in the world. So this is a kind of back to the future situation. And I think if you look at the industry argument, it is anchored in the language of Section 6. that Martha just mentioned, which is the obligation of EPA under Section 6A to impose restrictions that are to the extent necessary to eliminate the unreasonable risk. And in each one of the cases that are being litigated, a central issue is how that language should be interpreted. In the asbestos case, the industry argument is basically, well, we put respirators on our workers, and there's really no debate that if the workers are wearing respirators, the risk from asbestos exposure is going to be negligible. And so therefore, the additional step of banning asbestos use, particularly in chlor-alkali plants, was unnecessary to eliminate the unreasonable risk. And the EPA rejoinder in the litigation, and I think the policy response of EPA in the rulemaking is we're dealing with a chemical that is uniquely lethal and harmful, that has no safe level of exposure, and that over the many decades of its use is responsible literally for millions of deaths worldwide. And so do we really want to tolerate additional exposure to asbestos based on the hope and the assumption that everybody will be wearing respirators at the chlor-alkali plants, and they're going to be fully protected, and nobody is going to develop mesothelioma, and nobody is going to develop lung cancer, and no one is going to develop asbestosis disease. And so that's the issue that is before the courts. And I think that the way I would look at the language in the statute is that, of course, EPA does not have unlimited discretion to ban a chemical simply based on a belief that we need to go the last mile and be precautionary. But that said, EPA has a lot of scientific and policy judgment to look at the evidence and to make a determination, having characterized the risk of what is the most defensible action to take to assure that that risk is effectively addressed. And I would just submit that when you look at all of the 5 rules, particularly those that are being litigated in the courts, it's pretty darn clear why EPA decided that it needed to impose a ban. And I would submit that EPA's policy and scientific judgment was exercised in a very defensible way.
Now, Keith, my understanding is you're on the other side of the aisle on this case. How would you respond?
Well, so I'm not actually involved in the asbestos case, but I am involved in a few of these. I do think, so the initial question you asked is how much does that language to the extent necessary matter? It has to matter. That because it's the law. So I think, what we have argued repeatedly is that means that having identified an unreasonable risk, the assessment has to be, not only will this regulation eliminate that unreasonable risk, but is this necessary to eliminate the unreasonable risk? What the IT people tell me is that the foolproof way to avoid cyber attacks is turn off your computer. And yet we all still use them. In the methylene chloride case, there are a number of uses for which EPA prescribed an ECHL of, if I remember correctly, it was 2 ppm, and then a whole host of uses that they prohibited. And one of the issues in that case is whether the prohibition has any justification whatsoever, because the rulemaking record, the decision seems to say we have doubts whether these industries will be able to achieve the ECHL. That sounds to me like a far cry short of determining that it is necessary to prohibit those uses, because it's not a determination that it cannot be achieved. And if it can't be achieved, of course, then using it in those uses would be unlawful, because if you cannot use it without achieving the ECHL, then you can't do it. But the ban, instead of setting the ECHL, why is that necessary? I don't, that's a live issue in that case that I think the Fifth Circuit's going to take up. There's in the TCE case, one of the live issues in that litigation is that EPA allows the use of byproduct material that has trace TCE, that has small amounts of TCE in it, so long as it's being done on site, but does not allow you to take it to a different site to do the same thing, even though there's no finding in the record, I think, that the transportation in itself of materials that have got small amounts of byproduct TCE is actually contributing to the risk. So I think, where Bob and I might have a fundamental disagreement, I think we are probably on the same page. It sounds like that EPA is limited in what it can do by that language to the extent necessary. I think we would disagree about whether they've actually achieved that in a number of these rules.
So could I just offer a slightly alternative view? So labor unions have for 50 years fought against the notion that respirators are an effective means of protecting workers on a full-time basis. And so to the extent that arguing that EPA should set ECHLs instead of bans means that industry would have the option of requiring full-time respirator use, that would put an onerous burden on workers, one that in the TCE litigation, industry is arguing is completely unreasonable and will cause them to go out of business because the workers will refuse to wear them and they're going to have to shut down their facilities. But the unions have taken the position, and this is true in methylene chloride, that if the only way to reach an ECHL and fully protect workers is to slap them in respirators all the time, then EPA should ban the chemical where it can. Now, this becomes a lot more problematic for 6G exceptions, where EPA has determined that it can't ban it. And I can tell you that the unions have not yet taken a position on it. I'm not sure, but there's a real contrast between some of the representations that respirators will fix everything, and so don't worry, ECHLs are fine, and the position that some of the industry folks are taking in the TCE litigation that we can't rely on respirators because our workers will be up in arms. And it's certainly full-time reliance on respirators would be overturning 50 years of occupational health policy and industrial hygiene policy. And so we think that's a real non-starter, or it should be.
So I apologize, but this is really, really interesting, and I want to point out something for everybody what Ren just said. And I agree, these debates are ongoing. I do think that industry if industry is not a thing any more than, it's like everybody's different, every market is different, every product is different. There are some commonalities and some underlying principles, but it doesn't shock me that it would be that a thing would work and be economic in one market and not in another. But the underlying proposition that Randy was talking about is really about what do we mean by to the extent necessary. I don't know that in methylene chloride respirators are the answer for how everybody gets to the ECHL, and I truly mean, as I sit here, I don't know. I might have known last year, but I don't now. Um, but let us assume that the ECHL, that if there's a 2 ppm ECHL for this substance in a condition of use, that the only way the employer is going to achieve that is by requiring everybody to use respirators full time. Let's assume that, like, so, and what Randy says is that's a terrible idea. And I understand the concern there, but as an interpretation, if we ask the question, what is to the extent necessary? And I don't think this is an easy answer. I don't think it's an easy question with an easy answer. Like, should that concern factor into the question of what is to the extent necessary? Or should it be part of the selection of, as you select, like, what weight do you give that concern in the selection of measures? I think is not trivial.
That would maybe why we haven't heard from the court for a year in the methylene chloride case, right?
Right.
It's very complex.
Any day now, any day.
Yeah.
I'll just.
Again, let's explore this topic. And there are cases pending in the 3rd, 5th, 8th DC circuit. So we have a lot of opportunity for some mixed results here. Please go ahead.
Nihal,
did you want to go, or Randy, did you want to respond first?
Well, I would just say this is really getting into the weeds. In the case of methylene chloride, for example, it has been used in construction. The only respirators that work with methylene chloride are air-supplied respirators. It's unsafe to use them on construction sites because people are moving around all the time. So there's really no indication that Congress intended to mandate unsafe, impractical methods of compliance in lieu of just getting rid of the methylene chloride when there's substitutes that can be used in those instances.
That's a good word. Bob, please respond, but Marissa has been very patient. I do want to save a little time to talk.
Okay.
We have about 10 minutes.
I will try to be succinct. I don't think that we can really address this issue thoughtfully unless we keep in mind the level of risk associated with the chemicals that we're talking about. And when a chemical has serious toxic effects at very, very low levels of exposure and concentrations, it is in that situation where the agency needs to examine the pluses and minuses of relying on workplace protections that may be ineffective given the nature of the risk and the very low level of exposure as compared to taking the step of banning the chemical, which will provide a degree of protection against the risk that for that particular chemical, a respirator program is just not going to deliver. And I think TCE is a great example of this because the effects that were driving the risk evaluation for TCE we're seeing at incredibly low levels. We are talking about immunotoxicity. We're also talking about fetal heart malformations. And if you set an ECHL to eliminate those risks, it would be incredibly low. And in fact, industry said this ECHL that you wanted to impose is unachievable. We cannot get there. So if your EPA and industry is saying, gee, we can't achieve the level of workplace protection that EPA says is necessary, what do you do if you're EPA? I don't think you can just walk away from it and say, we're going to allow any level of risk that is appropriate given the limitations of controls. And so I think in a situation like that, and in the asbestos situation, and maybe in the methylene chloride situation, the effects of the chemical are driving EPA towards a ban.
Interesting. You know, there are lots of interplays in risk management, and one area we felt that was super critical to bring out in this panel discussion is also the state-federal interplay. And so I do want to turn to that topic, if we could here, in closing out our panel discussion. Consideration of substitutes, for example, is part of the economic assessment that EPA must conduct in a Section 6 rulemaking. And we have with us today one of the country's leading experts on conducting alternatives assessments, and that is Marissa from Washington State. So I'd like to ask Marissa to lead off on this. What role should the availability of substitutes play in selecting bans or other risk management options? How relevant is the safety of the substitute relative to the chemical EPA is regulating? Do states see the substitution issue differently from EPA? And finally, under TSCA or state laws, what should agencies and industry itself be doing to avoid regrettable substitutions? Marissa, I'd like to ask you to lead off on that, but also ask the panel and just open it up here in the last few minutes to also address state perspectives on preemption. So those two issues, substitution and preemption, please lead it off.
So I would suggest we let Marissa go on substitutes.
Yes, no, I would like Marissa to maybe take the opportunity to answer both questions, but please lead us off. Thank you. Thank you, Randy.
Sure. Thanks so much for having me. So, from the state perspective and the information we have, we often see the move to safer alternatives is kind of shaped like a bell curve. It doesn't happen all at once. And that means you have your early adopters that move to safer alternatives relatively quickly. And then you have your stragglers that might continue using your high priority chemicals for a long time, even after safer alternatives are feasible and available. And so if no one has switched yet, then you're really in this technology forcing space where you're trying to figure out how do you shake something loose to get people to move to a safer alternative, to find a safer alternative, to find something that's going to work and avoid a lot of the risks that we may be worried about. And that's the space that we find ourselves in with chemicals like 6-PPD, which is an antioxidant, an antioxidant, really toxic to fish, particularly salmon, but it also helps make our tires safe. So we can't ban it tomorrow. But we do want to find a safer alternative, and we do want to keep it out of our streams and away from our fish. So that's a challenging space to be in. But in other times, you're in a place where alternatives are already really widely used, and a lot of manufacturers have made the switch, and some haven't. And in Washington, we have research programs that help us pave the way for safer alternatives. And I want to highlight that these programs really rely heavily on concepts from EPA's Safer Choice program. We didn't make it up. We borrowed heavily from tried and true methods for finding and evaluating safer alternatives. But we also have a regulatory program for chemicals and consumer products called our Safer Products for Washington program. And under this authority, we can restrict chemicals in products when safer alternatives are feasible and available. And this concept works because we focus on a specific product or use. We set clear criteria for what it means to be safer. And usually we make that determination of whether it's feasible and available based on whether it's used in other products that meet the same functions. So by the definition, this isn't technology forcing. And there's a lot of fundamental differences between our state programs and TSCA. But this relatively straightforward approach has helped us assess the situation and figure out what are we going to have to do to get this chemical out of products? Is it innovation or is it regulation? And it can be both. And I want to take this approach and kind of expand it a little bit and give you an example, we want to look at the needs of the specific chemical in the product. And that's really important because if you think about something like PFAS in food packaging, it helps keep your leftovers, your food packaging protects your leftovers, right? That's good for about 3 days. You don't want to eat your leftovers after that. But PFAS is going to retain its oil and grease resistance for a whole lot longer. So when you're looking for alternatives, you got to think about what's going to serve the purpose of the product, even if maybe it doesn't meet all the same performance requirements of that high priority chemical. And I'll just end with, EPA has the opportunity to look to states' work to figure out how we think about things like safer alternatives, to look to Safer Choice. Safer Choice is an incredible program, and we rely heavily on the work that has been done under that program. It's good to look before you leap. You kind of want to know, where are we going if we ban this? But you also need to retain some simplicity in that process because government agencies aren't manufacturers, right? We can take a look at a high level and say, well, someone figured out how to do it, so we think it's possible. But we got to work together to figure out all the kinks in the process and have those conversations and talk through the nuances. So I think keeping it at a high level is really important. And I can dive into preemption or I can pause. Please let me know.
Yep. No, I'd love to hear how TSCA federal preemption looks from the state perspective 10 years into this, if you wouldn't mind.
Yeah, such a simple question too. Thank you. So we often share priorities with EPA, and that means we're working in a shared regulatory space. In a lot of ways, I think in Washington state, we would like to be preempted by protective national regulations. We do not have the resources to go at this alone, and regulations are often more effective when they're consistent. However, we have not seen protective and timely regulations coming out of TSCA, and there's just so much uncertainty from missing deadlines and redoing analyses. And that means we don't really know what to expect in terms of when and whether we'll be preempted on specific chemicals. And underlying all of this is our obligation to the people of our state and our legislature. We have to implement our state laws. And so that means we can't always take a wait and see approach. But it also makes it hard for us to act strategically. While we ultimately want protective national regulations, I would be really remiss to not stress the importance of state actions and the potential harm that comes from preemption by inaction. So I can think of a lot of examples where state regulations have led the way. So lead in wheel weights is a really good example. Washington state banned it in 2011, and a lot of states were with us in that. It was a big deal to get lead out of wheel weights. When you drive down the road, your wheel weights can contribute to lead in the environment. We know that harms kids' health. So this was a really important step. EPA just recently responded to a petition to take up lead in wheel weights under TSCA in the last couple of years. And they denied that petition because it had already been phased out because of state actions. So, we can think about similar products like copper in brake pads, flame retardants in electronics and furniture, phthalates in children's products. If we had waited for EPA to take action, we may still have lead in wheel weights. And that's a really important, point of this preemption. Like preemption by inaction or waiting for EPA to act would have meant a lot of loss of public health and environmental benefits. So it's tricky to navigate this, but in Washington, we're not viewing potential preemption as an excuse not to act to protect our environment. And I think state actions can also serve as a really important asset to EPA because it can provide that insight. We talked about alternatives, but what about examples where states have banned it? All right, now you can kind of be like, what happened in Washington when they banned that? Can we take that nationally, or is there something special about why it works in Washington that it wouldn't work in another state? Or maybe there's a need in Washington that there's not in another state. So state regulations are really important, and they can serve as a test bed for state action, for national action.
Thank you so much for your perspective. And thank you so much to all our panelists for really exploring these important issues with us today.
I hope you enjoyed this riveting discussion on TSCA risk management. For more information on this fabulous conference, please visit our website at www.lawbc.com. All Things Chemical is produced by Jackson Bierfeld at Bierfeld Audio, LLC. We will be back again soon to further inform and entertain you about all things chemical. Bye-bye.